When thinking about your financial future and the importance when you own property or you have other investments, having a living will or a trust, doing estate planning, things of that nature is always in your best benefit because you don't want to leave things undone for other family members in the event of an emergency or something should happen. So that's what we're going to be talking today about. And I have a very special guest with us. So, welcome to Smart Money Moves. I am Michelle Walker, and Smart Money and Moves That Matter. And today with us that we have Bruce Neilson, and he is a real estate attorney. That is his specialty. He's an attorney of many things, but that is his specialty. And he works out of the Veeder Financial Office. And George was our guest last week. So Bruce and I have done a little bit of work together over the years, and he actually helped me prepare some documents when my mother's house, when she was diagnosed with pancreatic cancer, and I needed to do some living will and power of attorney stuff with that. So he helped me out with that, and I'm so grateful for that. So I thought maybe I'd bring you on today, Bruce, and thank you so much for joining us.
All right. Well, thank you, Michelle. It's really nice to be here. Thank you for having me.
Yes, and we have, I have so many clients over the period of the years that I've been working as a loan officer ask me about, what's my next move, especially first-time home buyers, right? So we have first-time home buyers, people that are upgrading or obtaining several investment properties, things like that, who don't have any of that financial or that living will, trust, or anything, life estate planning put in place. So we'll talk about that. But right now, let's just talk a little bit about Bruce Neilson. Bruce, what made you get into want to being attorney? We'll just find out a little bit about who you are and why this is such a passionate career for you.
Well, I guess going back to college, I was in the College of Business, and I had to take a business law class. The business law class was taught by a local attorney there in the city where the university was, and he just impressed me that you could tell he loved what he was doing, still years and years and years later. And I said, I don't want to get out of school and do something that I hate, because I hadn't made up my mind. If you're an economics major, which I was, I said, what are you going to do with that? Teach economics somewhere? That's kind of crazy. So I thought, well, then maybe I'll apply to law school. He really liked it, and so I did. The law interested me from when I first started law school, and I just stuck with it. I moved here to Fresno, worked with a firm who had some older partners who had a lot of the old timers of Fresno as their clients, and they were aging, and they were planning their estates. So I worked with them a lot and saw how that process worked, and it just has kind of stuck with me.
Now, did you feel like, because it stuck with you, did you feel like it made a relevant impact in the people that they were dealing with, that gave them some relief, some sense of security about what they were doing with these people? It wasn't like, so I'm handling a case, or I'm, handling family law, or doing something. Like, you're really bringing something with this type of law that is financially preparing them for the future. Was that a peak of interest for you?
Yes, I mean, overall, the law is, very flexible. You can do all kinds of things with it, but mainly what I liked about it is that you're usually helping people with some situation.
Right.
You get involved with different people, so everything is always a little different. It's not that routine, really. I mean, some parts of it can be, but every family's a little different, every situation's a little different, but you're helping them. That's what I liked about it.
Yeah. And what greater gift is that than to help somebody prepare and feel comfortable if something should happen. So let's jump right into topics that I know that our audience will really want to hear about. And let's talk about living wills. Okay, so who and when needs to get like, do you need to be young, have several properties, older, have several properties? When is a really good time to start that process? And tell us a little bit more about what a living will or a trust is.
All right. Well,
Two different things, though, I'm sure, right?
yes, most people have heard that term a lot, living trust, you
Yes,
know,
that's the one I was trying to
and
think of.
in reality, it just means you made this trust while you're living.
Okay.
There's no real magic in that name, but because there are various kinds of trusts, and the living trust, the traditional living trust that is used in estate planning, is what we call a revocable trust.
Oh, good. Yeah, I wanted
So
to ask about
the
that.
idea of that is that because it's revocable, you're not locked into anything. You still live your life like you always have. Your property, even though it's in this trust, you have full control over. You can sell it. You can buy more. You can. It's really invisible. But the magic of the living revocable trust is that upon your death, since the trust owns your property, now you're the trustee, so you're still in control. But because you are your property is in the trust name, there isn't property in the name of a dead person. That's what causes the thing that everybody hates is probate.
Yes,
Okay.
that's a very bad word.
So in California, when you die, everybody owns this pile of stuff,
Right.
right? Your house is in there, your cars, you might have a bunch of other stuff, maybe a business, and some of that stuff in there is because it's in the name of a dead person. When you die, how's it going to get transferred to someone?
Right. How is that distribution going to be handled?
Yeah,
Right.
and because you're dead, you can't execute a deed.
Right.
So that's where probate comes in, and so it has to be submitted to the court to either deal with a will or no will. That's called intestate.
Yes.
So you're
There's that word again, intestate. I just crack up when I hear that because I think about my stomach and not my life. But
yes,
go
sir.
ahead.
That just means you didn't have a will. But whether you have a will or you don't have a will, if that's what you have, a will or no will, your property, because it's in the name of a dead person, has got to go through this court proceeding called probate. People don't like it because it can take, it's
Oh,
hard to get through one with less than a year. It can run $10,000 or $15,000, even for a small estate,
quite expensive.
and it just, it takes too much time in
Well, and
California.
in those matters, they're sensitive. They're time sensitive,
Right.
right?
Now, you can still, once you're appointed the executor of someone's estate, you can get property sold and stuff, but to get everything distributed out you have to get the probate completed, which is a year down the road and again, a lot of money down the road. So the trust avoids that because instead of this pile of stuff in the name of dead people, it's in the name of your trust.
That's correct.
It's still yours because you're the trustee, but when you die, the trust is sitting there holding this property still. So it's not in the name of a dead person. And you've said who is the trustee after you're gone. And you've said what that trustee has to do with everything. And because the trust already owns it, they can just do it. There's no year-long probate process. There's no judges involved. It just can be handled simply and directly.
And what a relief and what a peace of mind that would bring to any family. So it doesn't really matter. Can you attach it if you don't have any property? Now, I think I pretty much know the answer to this question, but I think the audience might want to know is, do you have to have property to attach it to, or can it just be things that you own, cars, antiques, things that you own that are of precious value to you? Or should it be something that you do once you start obtaining property or properties?
Well, you need some kind of an estate plan, even if you're just a young couple starting out,
Oh, okay.
because if you have any children, if something happens to you, who's going to be their guardian?
So it can even
So
cover matters,
there's
personal
other
matters.
things that are involved in an estate plan. You don't need a trust to do that, but
Estate planning
you
you do.
need to
Wills.
think about the things. And it's not as complicated. Most people, the main question I get from people is, okay, give me my list. What do I have to bring? I got to do some research. What do I have to bring in before we can get started in this trust? And I say, bring in nothing. You have it here in your head, who your kids are, who you want to get your stuff. That's
Most
all you need
important
to know.
information usually stays
People
with
put
you.
it off because they think they have to make some big production before they come in and talk to an attorney about their estate plan, and you don't. That is the biggest hang-up that I found with people starting. They think they have to be, it's a big production, and they avoid coming in.
Well, that's a huge relief or peace of mind for people too, because if they think they have to have all this information or, bring all this extra paperwork or, information to you, and it's simply just putting in that which you hold valuable.
Right. Now, my philosophy on these trusts is what you're trying to do is avoid probate, but not unduly complicate your life, because there are things that don't require a trust to avoid probate. For example, life insurance, that's a contract with you and the insurance company that says if I die, this person gets money. That's what's going to happen no matter if you have 16 trusts that say something else. The financial institution is going to pay it to whoever you've said. The same thing would apply to investment accounts, even bank accounts. Your checking and savings account, most people don't know this, but you can put a beneficiary on those accounts.
Yes.
Usually they call it a POD, payable on death, but it's just a beneficiary saying, if this person dies, this person gets the money. So those assets aren't probate assets. They're just going to get paid directly to whoever's designated. What causes the probate, and this is what mainly puts people into the trust situation, is real estate.
Oh, it is the real estate factor.
Real estate, or if you own a business.
Okay.
You're in a partnership, you have an LLC or a sub-S corporation, some kind of business operation, that you can't be dealt with if you die without a probate unless you've put those partnership shares or the corporate shares into your trust to help to take the probate out of that too. So that's the main things that cause a probate. Things like your vehicles and furniture, and in California there's $184,500 rule.
What does that mean?
So
I'm interested.
There's an amount that by statute they've said if it's this amount or less, that this tangible personal property can be collected by an affidavit without a probate. So if you died and you had $180,000 in the bank and no designation, your heirs could collect that money if that was the only assets outside of your trust. What's in your trust doesn't count for that number, but it's an amount that the legislature's decided that on a smaller estate, it can be collected for tangible personal property, or even if it was real estate, but this is not very common that there'd be real estate in California worth less than $184,000. So that doesn't come up too much. But even if it was, there's an abbreviated procedure for property of lower value.
Okay.
Okay, so you can avoid low value estates. It's not a big of a risk for probate.
I see. So they measure it by the level of risk, or pretty much how much you own.
Yes.
And what's all involved. So not everything is subject to probate.
Right. But it's not a net value test. In other words,
I'm learning so much.
If you had a $300,000 house and you had a $280,000 mortgage, that's still $300,000 for
Correct.
Probate purposes, not just the equity.
Okay.
Yeah.
All right. So it's just, it's definitely something that you would need your advice on. And some people, but I think this gives us a lot of really general information about how important it is if you do have assets or property or corporations, that you define what's going to happen in the event that something should happen to you. I think that makes life, because I know that, like I said, a lot of my clients have gone through probate and wanting to get matters settled without, and just it could just linger on and trail on. Even real estate agents have properties that are in probate that they try to sell, and they think that they can sell them in a 30, 60, 90-day period, and there's never any guarantee of time on when those matters will be settled.
Right.
You could hear one date at one time and it just be pushed out and pushed out and pushed out because no one's in agreement, right? So tell me about trustee trustor. What does that mean in regards to the will or the trust? I'm sorry, the trust. What do those terms mean?
All right. So the trust that we're talking about, that is going to hold title to your assets so that they don't go through probate. The person who is putting their property into the trust, that's called the trustor.
That is the trustor.
Or the settlor, or the grantor. Those three words all mean the same thing. It's the person granting the property into the trust. That "or" at the end means the same thing for all of them. Trustor, grantor, settlor.
Okay. And the E is the person who's going to be handling.
The person handling it is the E.
Okay.
Yeah, the trustee.
I like that. So now explain to me, there are often times where families get in huge disagreements about who's going to do what. And one thinks the one should be the trustee. The other thinks the other should be the trustee. Like, it's ultimately the trustor's decision on who they're going to name the trustee. The one they feel the most is going to be the most, reasonably level-headed person to handle that business.
Yes. I mean, there's a number of factors. So typically it's a family. So it's parents creating this trust and their children, assuming they're of age.
Right.
Are probably are going to be what we call the beneficiaries. That's who's going to get things from this trust. So somebody has to be in charge when the parents are deceased. So if usually I say that one of the kids or the people who are getting stuff, the beneficiaries, it's pretty normal for one of them to be the successor trustee to get things distributed, because they're the ones who are interested in getting it done. If you're not getting anything out of the trust, you may not be in a big hurry to get it done.
Yeah, I mean, they are pretty much the first to entitlement. So, yeah, but typically in the ideal sociological world, it would be the eldest of the children, if that person is the most responsible. But it doesn't always necessarily mean that it's true. There could be other siblings too. There could be brothers, sisters, that would handle it because they don't have anybody else to, but generally people will pick the person that is the most trustworthy, or they think that it's going to be the most fair.
Yes.
Because everything's named in the trust anyway as where it's going.
A common dilemma for the parents when they're picking the trustee is they don't want to hurt somebody's feelings.
Yes.
Okay. So I get that all the time. So, well, if I make this child the trustee, then this child's going to feel left out. When the trustee really, is the one you're giving more work to. It's not the one you're benefiting the most.
There you go. Yeah. That explains it in the best way. It's like, well, maybe they don't want the job.
Yeah. And so I like to say, well, you can pick the one that you think would handle it the best, but we can say if they can't do it, this other one is the alternate. Now their name's in the trust, so they feel like they're still involved.
There can be alternate trustees.
So
you don't have to just name just one.
No, you should name an alternate, because you don't know. We try to write the trust so that when things happen in the future, you don't have to run in and make a change right away.
See.
you've kind of thought about alternatives that could happen, and you've dealt with them ahead of time. So you name alternate trustees. You also consider where these alternate trustees live on where they are. If you have an estate that's going to have a whole bunch of real estate in the Central Valley to sell, you might not want to pick the child that lives in New Jersey to do it. So where you are may have something to do with it.
Location, relevancy.
Or the child that's in the military, or something like that, that may make it difficult for them to handle it.
I see. Now, if there was certain people that were named as trustees, and say something happened to all of them and they were no longer, able to, or something, just in any case, how many names can you have as a trustee?
Well, I mean, there's really not a limit. But
Okay.
usually, if you name a couple of one or two alternates, that's usually enough.
Okay.
But
in your experience, that's what you've seen.
Yeah, usually.
So
we
somebody
have
always
two
usually
alternates.
names at least two.
Yeah. But if something were to happen and the parents died without fixing their trust and all the alternate trustees were deceased, then
Yeah, I guess that was more geared towards my question.
whoever that was, what would happen is the remaining beneficiaries would have to apply to the court to have the court appoint someone.
Now, is that a
And that's
timely
not-
process as well?
Well, it takes some time, but it's not a horrendous process as long as nobody's fighting about it.
Right.
If you have two beneficiaries left and they're fighting about who should be the trustee, then yes, then you could take a little time. But so that's why we want a couple of alternates in there already.
I see. That's great information. Thank you, Bruce. That really cleared a lot of things up, because I too had a lot of questions about that as I get to prepare. I myself have to prepare my trust. And of course, you'll be helping me with that. And I need to, I have 4 children of my own, right?
Oh, you have 4.
I have 4 children. And they all love their mom, right? We'll take care of it. I'll do this, I'll do that. But it is really, you want to make your best decision. And it's not personal on who's the trustee. It is not. It's just who can actively take that role. And because everything, what I think most people need to understand is everything is already named in the trust as to where it will go.
Yes.
So it doesn't matter who is telling the information, because it's already been ratified in a trust.
Right.
So it's not the person who is named trustee is going to get the most. And I think that that's a very important point, especially as parents try to explain this as they're preparing their trusts, and try to explain this to their family members. I think that became very clear to me, as it will to anybody who's watching this show today. So I think that's great information. Now tell us about estate planning. Is that the same as a trust?
Well, a trust can certainly be, in many cases, part of your estate plan.
Okay.
But the estate planning in general is just planning for the time at which you pass away, and how your property and maybe even yourself need to be dealt with.
Okay.
So, for example, a complete estate plan should involve the trust, if you need a trust. Okay. We usually do what we call a pour-over will. So even though we did a trust to handle everything to avoid probate, we're still doing a will for you. Now, why are we doing that? I thought, will bad, trust good. But
Will bad, trust good. I like that.
But the will in the trust situation is there really as a backup. Let's suppose you created the trust, put your property in it, then you, because you're Michelle, you run out and buy some other rental house or something. You're always out busily investing and doing things. And the bank normally will make you take title in your name, because they want the loan in your name and the deed matches the loan.
Right.
So, but then you, after the property closes escrow, you can transfer it into your trust. But you forget to do that because this is 5 years from now, and you did the trust 5 years ago, and you forgot you even had the trust. So what's going to happen? And then you were driving home from escrow, and you got in a car wreck and died. We talk about a lot of unpleasant things when we do estate
Bruce,
planning.
it's important. Make the point. I can get it.
Yes. So you're dead, and something's still in your name. It's not in your trust. What's going to happen to that?
Tell us.
So that's why you have the will. It says that if I left anything out of my trust and it's still in my name, by this will I leave it to the trust. So the will pours anything that was left out into the trust. So the trust still, your estate plan is still intact with everything, even stuff that was left out, because it pours it into the trust deals with it.
So important. Did you hear that? So important that you have a will and a trust.
Yes, you should have both. It's a backup.
Especially if you own property.
Right.
Especially if you own property. Again, you can, and what a way to kind of make sure that you're covered. Because I know all the time, even in my industry, when we close escrows, a lot of people want to close in the trust. Well, we have to provide a full copy of that trust to our underwriters at the banks so they can read them and determine whether or not they're legally good enough to close in the trust, because there might be some verbiage in there that says, we can't approve this, you're going to have to close outside of the trust, put it in the trust later. We find that more on, like I'm sure, and goes right into my next question to you, is the revocable, non-revocable. That's mainly what they want to see. They want to see if it's a revocable or non-revocable. So not only is it important to know the difference and see the difference of having a will and a trust, but tell us now about revocable, non-revocable trusts and what those differences are.
All right. So, yes, I think the lenders, they're getting a little, I'd say 20 years ago, there was no way the loan it would close with the property in the trust.
No, yeah. And I was working back when they did that, and it was like
they've loosened up a little, and they look at them, but they're looking, you're right, because if it's revocable, it's really you, the person who created the trust, you're still responsible. This revocable trust has nothing to do with protection from creditors. I want to make that clear. So this is purely for estate planning and avoiding probate.
Okay.
If it's revocable, you're still in control over it, and so your creditors can access the stuff that's in your trust. If you're in financial trouble and you have a legal judgment against you,
a lien,
that kind of thing, it doesn't really help that situation, the revocable trust. It's mainly for this estate planning, avoiding probate idea. Now, if you have an irrevocable trust, that means that you've given up all control over whatever you've got in that irrevocable trust. It's out of your estate, it's out of your life, and your creditors can't reach it because it's not you anymore. You're not in control over it. Okay, if you retain some kind of control, then maybe creditors can get at it. But ordinarily, what you're using an irrevocable trust for is to remove it from your control, from your estate, permanently, because once you've put it in this irrevocable trust, you have nothing to do with it. It's not yours. Now, the trust can be used, a lot of times what it's used for in estate planning is to hold title to to assets, to reduce your estate in a situation where your estate may be subject to the estate tax.
Oh, I see.
Okay. Mm-hmm. So if you're going to pay estate tax and you're trying to get stuff out of your estate, you can gift things into an irrevocable trust. Now it doesn't belong to you anymore, so it isn't counted by the government when you die. Okay, but it still could go to people that you want. It's just that it's out of your estate and isn't subject to your control any longer.
And can you make the same changes in an irrevocable as you could in a revocable?
you could change beneficiaries to some extent, but you can't make a lot of changes like you can with the revocable trust. That's the point, is that since it is revocable, you can change anything you want.
Right.
If it's irrevocable, you can't really change it a lot.
That makes a lot of sense because now I know why they wouldn't accept revocable trusts. I guess it's more specific to irrevocable as far as the lender's desire to want to allow to close in one. So the that's what I see more come across my desk when people close in a trust is the irrevocable trust, because generally they have all the properties they've wanted to acquire, or is it that when they're in a revocable trust they probably want to add more to, and being able to change that because maybe they're in a younger space, or do they change it from a revocable to an irrevocable as they get a little older? Tell me, does that have any play or desire in changing a trust?
Usually not. Usually the irrevocable or the permanent trust is, like I said, used to get property out of your estate. Or traditionally, what happened a lot. Now, when I talk about the estate tax, it's kind of a red herring because it doesn't apply to too many people anymore.
Right.
It used to apply to an estate of $300,000 or $600,000. Now it's over $12 million before your estate incurs any estate tax. So that's, for most people, that's not an issue.
No.
Now, next year it's going to come down. I mean, the current plan expires and they have to come up with something, but we're not thinking that it's going to go somewhere really low and crazy. It may be 5 or 6 million.
Just maybe like they're just going to cut it down a little bit. Yeah, I know that the estate tax didn't apply to anything. I thought it was under 10 million, or over 10 million. So anything over 10 million, but it is over 12 right now.
Yeah, it's been going up over the last.
That is pretty high, and doesn't apply to most people, just generally the wealthy.
Each person too. So husband and wife, that's over 24 million.
Wow. Okay, so it's per person.
Yes.
Oh, okay. Okay. So taking it out of the estate and putting it into an irrevocable means that's this permanent placement into that. Okay, that makes so much sense, and that is such great information. Now, when people have large asset accounts, financial, like life insurance, retirement accounts, stocks, annuities, things like that, is it something that you highly recommend that people get a living will or a trust, revocable or irrevocable, when it comes to having large portfolios, financial portfolios?
Well, that primarily depends upon what they want to happen to that money. Because if it is just money, you don't really need to have a trust to avoid probate, as long as the account designates who's going to get it.
Right. So if you're not placing beneficiaries on said accounts, whether stock, retirement, annuity, then you could be placing yourself in a position where you would have fighting family members, or you'd have some discrepancies within the family.
Well, yes, if you have no beneficiary, then yes, it's going to be in your estate and it's going to have to go through probate if it's over that $184,000 number that I previously talked about.
Where did they come up with that number? That is such an odd number to me.
Well, when I started practicing, that number was 60,000. Wow. And then they went along and thought, well, they should raise it. And so I think sometime in the 80s it went up to 100,000. Then, I don't know, 5-8 years later, they raised it to 150,000. And then they put it up to an odd number, 162,500 or something like that. And they decided to index it so that they don't have to just wait around till the legislature decides to do something about it. It's going to automatically increase every couple of years by a percentage that is going to be published. So Now, every 2 or 3 years, you got to look at the code and see what it's up to. So I think next year, it adjusts again. So it adjusted from 162 to 184, and then in another year it's going to adjust up again. But what that is doing is recognizing that there is a minimum amount that should be able to be conveyed to the heirs without a big production.
Right.
That's the idea.
Okay. So in closing, I just want to ask you this really important question. What is your best advice to people that could be watching this on the importance of having a will, a trust, and estate planning? I was going to get into power of attorney too, but I think that just goes along with,
That's part of the estate plan.
that
yes.
is just all part of the estate planning. So
Besides the trust, the will, powers of attorney are there to make sure that if you become incapacitated in some manner, you've designated someone to to make decisions for you without someone having to go to court.
Right.
The whole estate plan is trying to keep you out of court.
Right.
That just complicates everything.
So young, old, anywhere in between, indifferent, doesn't matter. If you own property, mainly, a lot of those things, like just assets, won't be decided by probate. Mainly property.
Mainly.
So as soon as first-time home buyers, as soon as you find yourself in a position and then you close an escrow, it's really important to start thinking about preparing a trust, because you just don't know what life event will happen. And I think it's so important that we start taking a greater look at this. I mean, so many times people don't have any preparations in place. And I've seen that in my own family.
Yes.
I've seen that in families of people that I love. And so I thought it was really important. And thank you for coming here and sharing this really great information with us, Bruce, today. And I'm sure that my audience is going to find it very useful. And just thank you for spending some time with us today.
All right. Well, thanks for the venue, and it's great to get the information out.
Yeah.
Thank you, Michelle.
Yeah, you're very welcome. And if you want some more information on how to start planning this, please feel free to message us here on this. And if you like the content and the information that was shared here today, subscribe to the channel, like and share. I'm sure this information would be more than useful to get out to your specific sphere of influence, your family, your friends, your coworkers, as it is all something that can be used by so many. And I just want to thank everybody for tuning in to Smart Money Moves, and stay tuned for our next episode, which will be coming up soon. And I won't spoil the guest for you, but it'll be somebody really cool. Thank you for chiming in, and you all make it a great day.